Who gave the orders? Who talked to them? Nobody's talking. This is proof of a conspiracy, because a conspiracy is collusion between two people with fiduciary responsibilities that are not allowed to collude together. The record was purged without the participants' knowledge. When officials collude with others to cover up for improper or illegal acts, it is a conspiracy, which is clearly not a rare occurrence in Washington. Once again, I repeat, the principal reason the Constitution is dead is because there exists a conspiracy of power that controls both political parties at the top, about 75% of Congress, a majority of the Supreme Court justice, and the executive. They take an oath, they give it lip service, they often rule in accordance with it when it's convenient, and then outright violate it with impunity when necessary, because there is no one who will prosecute them. And when you can do that without legal consequences, I repeat, the Constitution is as good as dead. It may live in your hearts, but it is no longer the supreme law of the land. What the powers that be tell law enforcement, judges, and congressmen and senators in secret has become the law of the land. That is why the Constitution is dead. And it's also dead because the vast majorities of citizens are ignorant of its principles and would be hostile to it if they knew them. Now, you say the answer is education of the people, but I tell you, because I've been in that education for many years, that when you really tell them what the Constitution restricts, they don't like it. If you told them that the principles of constitutional limited governments would prohibit even state governments from running public schools and charging everybody taxes to pay for them, they would be against it. I can tell you that even a portion of this audience might be against it, if you really like the fact that you can send your kids to public schools without the appearance of having to pay for it. But we have to understand that there's a violation of other people's rights, other people's property rights. So, let me cover two major problems relative to citizens being dead to the Constitution. One is this public education system. And you say, well, let's take control of our schools. Well, in the first place, they're not our schools. They're run by majority rule. And unless you have majority, you can't even control a school board. Now, if you were to even get on the school board, I'm here to tell you, somebody who's dealt in the planning and governmental process, been on a planning commission before, that even when you want to start to preserve people's property rights, the city attorney speaks up and says, no, 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 you can't do that. You must, in fact, plan and restrict property rights according to the zoning laws, because the Supreme Court in this case has mandated that states will zone and do so according to the law in the various case studies. In other words, even as a person who didn't believe in zoning and wanted to protect property rights, I was prohibited as a planning commissioner by threat of lawsuits from the own attorney within the city. And it's the same thing on the school boards, because the courts have ruled that you cannot, in fact, start to exempt people who don't attend public schools. And you couldn't even do it as a school board. One of the reasons, though, that you can't control public education, and that you should control it, is because it has tax funding from everyone. And that's why we are not allowed to control public education according to your religious values. You're not allowed to pray in public schools. And to a certain extent, there is validity to that. When you're taking everybody's money, you shouldn't be able to use that money to violate their own religious rights or opinions. All education has values. Now, the answer to that is not that I'm justifying saying that you can't have religious values, but I'm saying you shouldn't have public schools with monopoly tax funding. All schools should be competing. All schools should be operated by user fees. That's a major change that occurs, and I attest to you, if you couldn't pass it in Utah, you can't pass it anywhere in the United States. But slowly that has to change, and it could change if enough people understood the principle behind it, because people who support public schools would and could understand the principle of fairness if they could get over the greed of realizing that it would be that they would have to pay more if they want to stay with those very big and expensive schools. The other basic problem that we have is citizenship by birth. There is no requirement to be qualified to be a citizen of this country. And I want to tell you that the best of the founders believed in citizenship by qualification, not by birth. In fact, you want to remember that in the Founders' Day, only men could vote, and they didn't believe in universal suffrage either. And the reason they don't want to have everybody having the power of the vote is because it takes a certain amount of understanding of law and constitutional theory to be able to vote properly, lest you have majority rules that take away your rights. In fact, one of the problems with even having fundamental rights in a constitution is that technically the majority can vote away any of your rights by majority rule, and that cannot be allowed. Fundamental rights are sacrosanct, even as difficult as it is to define them sometimes. Nevertheless, you do not ever, a nation of corruption of public schooling where they tout socialism, they promote it, and they don't teach anything about constitutional restrictions. And unlimited birth, unlimited entrance, even illegal aliens can drop a baby in the United States and have it be called a citizen. And that's what leads to all the controversy of trying to remove illegals. They talk about breaking up families. Why are they breaking up families? Because all the children are citizens. And they've purposely done that by court interpretation, by the way, not because it was part of the original Constitution. They've done that on purpose because they want to create a conflicting environment that the courts will have an excuse to overrule, mandating illegal aliens be extradited or evicted from the country. Now that's the problem with the Constitution being dead. Now the fix. First of all, I want to cover in the fix what doesn't work. Working through the system doesn't work, ladies and gentlemen. Now this is going to be the most difficult part for you here if you've had any education from any of the many wonderful constitutional groups. Because the things I'm going to talk about not working are the things that we have been taught for many years within the conservative movement are the things that we must do. One, working through the system. They control the system. They control the courts, they control Congress, they control the media, they control the electoral process, and now with electronic voting, they can even control the votes. It's very difficult to change it working through the system. A great legal scholar, J. Reuben Clark, once said, once you've lost your freedom through majority rule, you never win it back by the vote, only through bloodshed, only through revolution. And he's right. The majority, once they become corrupted by benefits, will never give you back your freedoms. Just like the voters of Utah will never give you back your freedom to have private schools without having to pay for public schools. They won't do it because it would make them have to pay for their public schools, which they want. If conservative Christians in Utah won't give you back your rights, much less the rest of the country won't do that. If they understood the Constitution, and that's why there's a great deal of resistance to a lot of people to understand the Constitution in the tradition of the founders, because it basically says government can't give me any benefits anymore. It can't protect me from people discriminating, and discrimination happens to be a fundamental right. The right to choose whom and with whom you'll associate, to make judgments about people. It's a fundamental right. Even racial discrimination is a fundamental, much as we might decry it. If you don't have the right to discriminate on race, you don't have the right to discriminate on weight, you don't have the right to discriminate by sex, you don't have the right to discriminate by sexual orientation. And you notice that's exactly the way that the law is following now. Few people realized in the civil rights movement we lost a major fundamental right by declaring private business a public business because they serve the public. And therefore you have no right to privately discriminate because you're public now. Just simply a distortion of law. But they control the system and the courts. And the problem with the courts is the baggage associated with interpretation. Most of what we talk about in the conservative movement is what? Restore the Constitution. Isn't that true? Isn't that the primary thing? Isn't that our champion call? We must restore the Constitution. I'm here to tell you the practical difficulties of restoring the Constitution. In the first place, the look that you get from the establishment medical field, and I've been around the medical, I'm not the medical, but the legal field, legal profession. My father was a lawyer. I worked in his office. I graduated in pre-law and political science, and I've written books on the Constitution and law. And I'll tell you, there's a world of difference between people inside our movement talking about restoring the Constitution and lawyers and judges outside. The first time they hear when you say, we want to restore the Constitution, they say, what do you mean? The Constitution's right here. It's on the books. We live the Constitution. What do you mean restore it? And so you say, oh, we mean for you to restore it according to the tradition of the Founding Fathers' original intent. That's what we mean. Well, so do we. Let me quote you from Justice Stephen Breyer, one of the liberals on the bench, an activist judge. He complains that Americans think we decide things on the basis of politics, or if not politics, on the basis of what we think is good for the people rather than the Constitution. And I think that's wrong. Even when the justices disagree, all 9 of us think we're following the same Constitution that was there in 1790. Now, he's not really that naive. I think he's lying. Just like the Republican establishment was lying in the Pledge to America about pledging to honor the original intent of the founders. He continues, and listen to this. In interpreting a law, judges typically look to the words at issue, to the surrounding text, to the statute's history, to legal traditions, to precedent. There are hundreds of thousands of case law, and they are just as binding in the legal field as the words of the Constitution. You can't say and quote something with the Constitution in a court of law without showing all the precedent that interprets that doctrine. He says you have to look to the statute's purposes and to the consequences evaluated in light of those purposes. Of these, I find the last 2, purposes and consequences, to be the most helpful in interpreting law. However, many of those things he listed are contradictory. In fact, by giving a higher priority to consequences rather than original intent, he is therefore able to justify his expansionist view of the document. Justice Brennan was even worse. He insists that current justices read the Constitution in the only way that we can as 20th century modern Americans. He conceded that they look to the history of the time of the framers and to the intervening history of interpretation, but Brennan said the ultimate question must be, what do the words of the text mean to us now, not to them? That is not originalism. Originalism is paying strict attention to the original intent, a model championed by Justice Antonin Scalia, current justice, who purports to apply constitutional text according to its meaning when it was adopted. And that's absolutely right. Most of the time he follows this, but even Scalia cannot be trusted to oppose the powers that be when they secretly communicate with the court that they must not rule on a certain subject. You know, the court has the ability to take a case or reject it, and they don't have to give any reasons for rejecting it. In fact, they can rule without comment, which I don't believe any court should be allowed to. In fact, they should have to quote chapter and verse from the Constitution. Scalia refused to honor his previous promise to hear Obama's eligibility challenge. So did Justice Clarence Thomas. So did the California judge who swore that he would give the case a full hearing, but just before the trial was to go to trial, he dismissed it without comment. Someone had got to him. Now, this was a judge who said openly in court, he said, I will make sure that this Obama-ability issue finally gets its hearing. Of course, I will not be deterred from this. And then without comment, he dismissed the case. It was a couple of months later. Somebody got to him. That's another reason the Constitution is dead. They never apply it when it threatens to take down a major agenda of the establishment. Courts even sanction lawyers who incessantly bring up constitutional arguments that have been overturned by precedent as frivolous. The attorney who challenged Obama's citizenship, Orly Tace, was fined $20,000 on the second attempt on a different basis to challenge Obama's citizenship eligibility for president. Getting the justices to rule on the founders' intent and the specific requirements of the document was not allowed, and they fined her $20,000. Guess what? That went back to the Supreme Court on appeal, and they refused to hear the case. There are 4 supposedly conservative constitutional judges who refuse to hear that too. That's why I tell you I have no confidence that they don't control them. I happen to know that Justice Thomas was guilty of the charges by Anita Hill at his confirmation. He did have moral indiscretions. They covered up for him because now they've got control of him. That's the same thing with House Minority Leader John Boehner. He's now been revealed that he had an affair. The government keeps track, and surveils every single state and local legislator, state representatives and senators, to get dirt on them. That's part of the illegal surveillance. They legally surveil every congressman and senator, and they keep those files on dirt on them, just like FBI Director J. Edgar Hoover kept it on the Kennedys in order to keep himself as director of FBI, but it works both ways. And they use these types of things to get people who aren't knowing conspirators in the full picture to do their bidding. So it's very sad that not a Supreme Court justice would come to the rescue of this eligibility claim, which is one of the greatest violations of the Constitution that has occurred in the past century. Now, how about getting Congress to take action? You know, it only takes a majority in Congress to make certain subjects off limits for the jurisdiction of the courts. They could have done that with abortion, to keep abortion from being overruled, but they refused to, even when the majority was in power, were Republicans. They refused to confirm true originalists to the Supreme Court or to the Justice Department. When liberals are nominated, the conservatives are pummeled in the press if they insist on ideological criteria like strict constructionism, and they are expected to compromise. False conservative Republican presidents only present nominees who can win nomination because the liberal Democrats keep blocking the nomination. The last one, Elena Kagan, just plain lied about her activist judicial background, and she claimed to be a strict constructionist. It's just incredible how they will lie with impunity. And then, of course, there's a refusal to impeach the president on constitutional grounds. You know, I sadly think, ladies and gentlemen, that we're facing the same situation we did in the revolutionary times. That we can't change Great Britain in their parliament. They will not give us our rights. The great advantage that the colonists had is that they were far away in their own area and they could declare their independence because they were already a separate portion of the British Empire. I believe, frankly, that we're past the point, because of the points that I made today, where we can change it working within the system by reforming the system. And the big problem is that the interpretations of precedent are inseparably connected with the Constitution. Conservatives can't even decide on what version of the Constitution would use to restore. You want the original version that allowed for slavery, that didn't apply any rules to the states? We know what happened with that one. We want the portion that incorporates the 14th Amendment, the voting of senators on a popular basis versus state legislators. I mean, all of those are issues that need to be discussed. What we must do and to understand is that you cannot restore the Constitution while it is inseparably linked to precedent. If, for example, as I say, you were able to restore the Constitution by having a certain amount of maybe a president elected, let's suppose a Ron Paul would be elected who would do our desire of having the Constitution enforced. You would have to have, of course, the judges back that up. You'd have to have Congress back that up. You'd have to control all of Congress. We have trouble getting even one or two constitutionalists elected, let alone an entire majority. It's a very, very big problem. But let's suppose, for discussion's sake, that we were able to get the view of the Constitution enforced. Let's suppose that we got a majority in the court and they said, we will enforce the Constitution on the nation verbatim, and the federal government no longer has any powers to do any of the entitlement programs. What do you think would happen? You would have rioting in the streets. You would have seniors. You would have ARP, that arch socialist organization of which I hope you seniors are not a member of, demanding, of course, that the Constitution be amended to allow that. And that's the problem after 200 years of softening up the people, getting them to accept soft socialism, is that I'm afraid that the Constitution would and could be amended, and it doesn't have any provisions which keep constitutional amendments from occurring that are in fact violations of fundamental rights, because the Constitution never did define fundamental rights, and fundamental rights aren't separate from the document. But if for argument's sake, we were able to, through the Supreme Court, demand that it be enforced, there would be that problem of the amendment. But there would also be that problem of the fact that the Constitution is still tied inseparably with court interpretations. So that every time the conservatives say, well, we've got to interpret the Constitution this way, the lawyers go right back to precedent for years, and they have hundreds of precedents that say, no, it can be viewed as this, and the commerce fraud can be used this, and the general welfare clause can be used to justify this. Let me tell you, frankly, what the only solution is, and it will shock you, coming from a nephew of W. Clone Skousen, which was a great champion of the Constitution, as written, and implied, as many of our Restore the Constitution groups do imply, that the Constitution is perfect as written. The only way out of our solution is to rewrite the existing Constitution in the same principles of the founders, but in tight legal language. Now, let me tell you why. It's the only way to beat the system. Because if you rewrite every portion in tight legal language, and you close up some of the weak spot and loopholes, it's a whole new document. None of the previous precedent has any validity anymore, because you've got to now interpret according to the new document. Now, lest you rise up in horror and say, I'm suggesting a constitutional convention. I am not. There's another way. You never want to get into a constitutional convention to do this, because you couldn't control it. It's like going into the English Parliament and saying, we want to write the English Parliament with you participating, and we want you to give us our rights. Will they give it to you? No, they'll just write you another socialist one. They'll write you one where they have the ability to tax you illegally, as they did the colonists. There's another way, and it's a very difficult way, but it's the only way. And in fact, it follows the principles that the founders began with. They believed in initial unanimous consent to start a constitution. When they passed the Constitution of 1787, what did they do? Did they simply say, this is now in vogue because we, the majority, voted upon that? Did they mandate that upon the other states? Because there were several states that did not vote to ratify, did they? No, they didn't. They believed in initial unanimous consent of the states. No state was forced into the Constitution until they came on board. They started to operate until all states did come on board, didn't they? Do you understand how that works? It doesn't mean that you can't start without unanimous consent. It means initial unanimous consent. That is, you start with less than the whole. You start with those that do agree. And you start to operate a government, and it works well, and it starts to provide protections for commerce and rights. And the other states who are on the outside, who don't have that protection, say, we better join. Otherwise, we're treated like a foreign country. And that's why they joined, even though they had objections. It's a good system. The only problem is the states themselves didn't allow the same right to the individuals. And you say, that's impossible. How could you get all the individuals? Well, it's the same principle. You start with those that will agree, and you treat the rest as non-citizens. And they realize, gee, it's not fun to be a non-citizen. I don't have any property rights. I can rent, or I have to agree, but I don't have any transit rights through theirs. And you give them motivation. You give them incentive to join. But you don't violate their rights. You simply allow them to be free. Now, it's very difficult to do without territoriality, and I don't want to go into all the difficulties of that. But in principle, the founders believed in that. They simply didn't have the ability to impose it at that time. But we can't win, in my opinion, by changing the system that's against us. They outvote us, and they always will, and they're getting, even though we're growing because of the Tea Party movement, we're still not growing as fast as the corruption that's growing, and you'll find that out when they finally try to take away Obamacare, and you'll see how many people want this socialized medicine, and they want to force those of us who don't participate in it to be brought into the system. That'll be one of the most difficult things to undo. But what we must do is consider the possibility of starting from scratch. And here's the second alternative, and that is we start with 1. We start with 2 and 3. And we get together our best legal minds within the constitutional conservative movement. And we sit down and say, let's rewrite the document in tight legal language according to what we feel like was the inspiration of the founders. And then we'll start to build consensus. Now, you say, what good is that? Well, the good is this. Because frankly, as I said, you never win by getting people once corrupted to give you back your liberties by the vote. At some time, I think the greatest chances are there will be crises that will evolve and fall upon this nation, if not the judgments of God. And during those crises, I believe that God will preserve a remnant. In fact, I think he will drive a remnant together. Pastor Chuck Baldwin, former presidential candidate of the Constitution Party, has just made a decision to give up his ministry of a very fine church in Pensacola, Florida, and moved to Montana with all of his family to seek greater liberty. And I've talked to Pastor Baldwin. He and I both are in agreement that we believe that only a portion of the nation can be saved in liberty, not the whole thing. Each one of us feels like we're a small island in a sea of unthinking humanity. We're all a tiny minority. How many of you feel like that? Even in this, the most conservative state in the state of the Union, you feel as islands in a sea of unthinking majorities. And hardly anybody wants to listen to your pleas about the Constitution. And I think that's true all over this nation. And it's even worse in the East Coast. He and I believe that at some point in the crises that follow, that there will be a driving force in God inspiring people out of the horrors of war and social unrest and perhaps economic collapse that might come, that people will be driven to areas of safety, driven by the circumstances of life, and as a result be open to systems of liberty that are still in vogue. And if we are not ready when that time occurs, not in the crisis to go through all of the legal thinking and difficulties of rewriting and tightening up the language of the Constitution so that it's defensible, we must do that in peacetime. That is my message to you. That's the most difficult thing to do. And frankly, I will tell you, the most difficult challenge to what I'm saying to you is the very constitutionalists that I'm addressing. Because you have been tutored by so many patriotic organizations that have taught you that the Constitution, because it is inspired, must be perfect. In fact, those of you who are members of the Church of Jesus Christ of Latter-day Saints, Mormons, have additional scripture where the Lord calls this inspired and even says that anything more or less than this cometh of evil. Now, a lot of people say, therefore you can't change it, Brother Skousen, because anything more or less than this cometh of evil. Well, I attest to you, you don't understand what the Lord meant.